Hi, my name is Malik Cutlar. I'm a partner with PCT Law Group. Today we're going to talk about retaliation. During the last few years, there's been a substantial rise in the number of retaliation claims filed by employees, and there's been a substantial rise in what courts consider retaliation claims. According to the EEOC, since 2008, more than a third of the charges filed with the agency have been retaliation claims. And in 2010, for the first time, more retaliation claims were filed than claims of discrimination. Retaliation claims often accompany claims of discrimination, but they are often more difficult to defend than the underlying discrimination claims. What are the basics of a retaliation claim? Essentially, an employer may not fire, demote, intimidate, harass, or otherwise retaliate against an employee who has filed a claim of discrimination or participated in an investigation regarding a discrimination claim. In order to establish a claim of discrimination, an employee must allege 1. That they engaged in protected activity, 2. An adverse employment action was taken against them, and 3. There exists a causal connection between the protected activity and the adverse employment action. In recent years, the United States Supreme Court has expanded and/or clarified the definition of an adverse action and who can sue for retaliation under Title VII. For example, in a recent case, the Supreme Court unanimously held that the fiancé of an employee who filed a charge of sex discrimination had standing to bring a retaliation claim when he was fired by the same employer just 3 weeks after his fiancée filed her claim. This case was unique as it involved retaliation against someone other than the employee who filed the employment claim. In that case, the Supreme Court stated, quote, Title VII's anti-retaliation provision prohibits any employer action that well might have dissuaded a reasonable worker from making or supporting a charge of discrimination. We think it obvious that a reasonable worker might be dissuaded from engaging in protected activity if she knew that her fiancé would be fired, end quote. In sum, employers must be aware that in recent years there has been an expansion of what constitutes a retaliatory action. More subtle forms of retaliation are being recognized by the courts as actionable claims. Therefore, employers should have a legitimate and preferably a documented, non-retaliatory reason for taking an adverse employment action against an employee who has raised a claim of discrimination or participated in the investigatory process of a discrimination claim. Thank you.